In this episode, we sit down with Dr. Zoi Krokida, a lecturer at Brunel University London, to explore the fascinating and sometimes complex relationship between artificial intelligence and intellectual property law. Zoe describes her journey into this exciting field and tackles big questions like who really owns AI generated content? We dive deep into how technology is reshaping the rules around copyright and trademarks, the challenges facing creators and platforms today, and what the future might look like as we strive to balance innovation with protecting rights. Join us for this insightful conversation. Hello, this is IP Stories by 4IP Council, a podcast about innovation and intellectual property. Join us and you'll hear about the journeys through invention, creation, and IP understanding of our guests. I'm Fernanda.
And I'm Marta, and we have with us today Dr. Zoi Krokida. I hope I said that right, Zoi.
Yes.
Lecturer in AI, Innovation and Law at Brunel University, London. Zoi, welcome to IP Stories. We are really looking forward to having this chat with you. And I think it would be good to start with a question that we ask a lot of our guests. And this is what attracted you to intellectual property and technology law? Was this always interesting to you, or was it like a journey?
So thank you so much. First of all, thank you so much for this invitation. I'm very happy to join the podcast today, and I'm very keen to discuss about AI and IP, intellectual property law. So, what attracted me most more to intellectual property law and information technology law? So, I was raised in during the 90s. At the time when internet was glowing and thriving, and the World Wide Web was part of our lives. And I was witnessing how internet transformed in a way our everyday lives, like shaping our habits, shaping our human interactions, shaping our behaviors. And at that time also, it was when the music exchange file platforms became very popular. So users were enabling all users to exchange files for free, music files for free. And a few years later, with the advent of social media, witnessing again all these advantages that internet had to offer, the social media blooming off,
Mm-hmm.
using social media as a communication tool, but also as a tool for exchanging content amongst users.
Mm-hmm.
So this served my motivation to study law at the first place, witnessing all these benefits um, provided by internet. I studied law at the undergraduate level. Then I continued with my master's degree, and I decided later to pursue my PhD in information technology law and intellectual property law. So having in mind all these advantages that internet had to offer, and witnessing all these advantages myself, that's why I was very keen to work on the intersection of intellectual property law and information technology law, especially looking at the content, all this material that is circulated online, and realizing how the rise of the power of the big tech companies, and the responsibility that they should have for the content that is circulated within their services. So this made me reflect further as to what type of laws, what type of legislation should be implemented, how laws should be shaped, so that the benefits, the advantages of internet can be maintained, but also at the same time to, in a way, to enable internet to evolve at its best version of itself.
It's true that those years were so exciting, right? And then with Facebook and like, yeah, suddenly we were all like amazed. I remember now you were saying it, and I was like, yeah, it's true.
And your answer was so great that if one day I have to answer the question of why I became interested about law and IP, I'll try to remember your answer because it sums up really well what we feel, I think, at least myself. You talked a little bit about technology, but why copyright and trademarks in particular?
So why focusing? You mean like on copyright and trademark? Why these are my
Yeah.
favorite intellectual property rights? So I first of all I focused my research on, and I was very keen to research further on these two rights because they are the most common. Copyright and trademark infringements are the most common infringements in the online world. So this was the first thing that triggered me and forced me in a way to motivated me to research further on these two topics. But again, as I said before, um, the circulation of content online, the circulation of unauthorized content online, and this kind of questions like who should be responsible for this? Are the platforms should the platforms responsible? They're just mere messengers, or maybe they're not anymore. Are the users that upload all this unauthorized content online, should they also be responsible for this? And how the creators, how authors can be remunerated for their works that are circulated online. So these are all these thorny questions were in my mind and triggered me to look at copyright law. And similar questions also arise with regard to trademark law. So think about all these trademark infringements that are taking place online with all these websites that are selling counterfeit goods. How the brand owners could safeguard their rights. Are there available effective remedies for the brand owners? And what about the users? Because something that I came across through my research, um, apart from the essential function of trademarks to guarantee the source, the origin of the good, of the product, trademarks are also transmitters of information. So this is also important, transmitter of information in the sense that users can exercise their freedom, their fundamental rights, freedom of expression and information by receiving and imparting information. So all these issues, I would say they push me towards the copyright law, push my research towards copyright and trademark law.
Suddenly, I'm thinking that maybe they really are the best IP rights. Those are such cool questions, though. Like I agree that it's such an interesting topic to investigate, and it's a lot about the rights of the consumers. So it's something that we see in our everyday lives. They are my favorite now too.
Well, I was hearing you talk. You sounded very passionate about everything, about IP, IT, copyright, trademarks. So I would like to ask you if you would like to share any memorable moments from your career, perhaps an achievement you're proud to have accomplished.
Well, I can think of some memorable moments so far. Well, I didn't start my career as a lecturer in academia. I started my career as a lawyer, working in law firms, in commercial law and intellectual property law. So at the early days of my my legal practitioner's career, I remember when I was chosen to do a Blue Book traineeship at the European Commission. I was a Blue Book trainee for 5 months at the cabinet of the Commissioner for Migration and Home Affairs, and it was the time when the cybersecurity agenda was introduced. So it was the time when there was a debate about this new legislation for online platforms in order to prevent cyber attacks. So this was, I would say, a memorable event in my career because this allowed me in a way to grasp a deep understanding of and insights of how the European Union is working in practice. So how the legislations, the EU legislative process, the EU directives, the EU regulations that we were being taught at law school, I was witnessing this in practice, how this works. So definitely this was a memorable event in my career. And apart from this, of course, when I finished my PhD and when I got my first academic job in IT, in information technology law and intellectual property law, so teaching and doing research at the same time, and turning also my PhD into a monograph, which my book, my monograph and my research focused on the of the legal framework of the online platforms and their responsibility for copyright and trademark infringement. So these were, I would say, the memorable moments in my career so far.
And what about nowadays? What's the primary driver of your career now?
Well, now as a lecturer, as an educator, my primary driver is to try to transmit all my knowledge, the knowledge that I have on information technology law and intellectual property law to my students, to guide them, to mentor them, to understand all these legal complexities, that all these legal issues that arise, the impact, the implications of new technologies on intellectual property rights, transmit my knowledge in terms of information technology law, for instance, about the history of internet, about the IP enforcement online, about the framework of the online platforms, about new technologies, about non-fungible tokens. So all this knowledge that I acquired through my research, my primary driver is to transmit this knowledge to my students as well, so that they can equip not only with knowledge but also with necessary skills to later, if they would like to work, for instance, as IP lawyers in authors associations or in the tech industry, so that they have a good understanding, a deep understanding of the peculiarities and the complex issues that revolve around information technology and intellectual property law. But also, apart from this, apart from my perspective as an educator, another driver of my career is to produce impactful research, and I try to attend conferences and share my research findings in public forums, so that in a way I can impact and I can encourage policymakers to make amendments or to initiate new proposals, new legislative proposals in the field of AI and intellectual property rights and information technology law.
I mean, I must say that because you talk with such excitement about every single aspect, I'm wondering, like, what do you like most? To work as a lawyer, or to be an educator, to be a researcher? Like, what aspect from your professional life do you think excites you the most?
Well, I think each of these aspects, they have their unique characteristics. So I cannot say like I like my days when I was a lawyer or now only teaching or only research. I think all of them, they provide me with satisfaction. So I really like all of these aspects in my career. So I cannot distinguish that one is prioritized, one is better than the other one.
Since you mentioned research, we know that there is an ongoing debate about whether AI generated works can or should be protected by copyright. And what is your perspective on how copyright law should evolve to address this issue?
Well, this is a very interesting question and timely for today, because today I just finished my lecture with my students on the AI law and ethics module, and this is what we're debating about AI
Mm.
generated outputs and whether they should attract copyright protection or not. Well, I think this is a very complicated debate. There is a tension between about this legal issue, but I think and this tension is represented by this the different approaches that exist. So, for on the one hand, the continental approach that mainly focuses on whether the AI generated output should attract copyright protection or not. On the other hand, the Anglo-American approach that focuses mainly on the ownership of that work. So there are like there are different approaches even in this debate. But I think the most important question with regard to the AI generated outputs is to first question whether first assess whether the AI generated output should be protected, and if so, under what scheme? So should they be protected by copyright? Should they be protected by sui generis right? And all these issues, all these questions, they have already been addressed in earlier days, back in 1980s, for instance, with the software. So looking at the Green Paper of 1988 of the European Commission, you can see like all these questions have already been addressed. So these are not new questions, but we need to find answers though to these questions.
Yes, it is. It is a very complex subject, and actually, I was wondering if there is any particular case or issue that you have encountered that highlights the complexities of this topic.
Well, I think that apart from this, this is a very complicated debate. But I think an issue that has an equal importance is the issue of liability for AI generated unauthorized works. The issue of infringement at this stage, and this has not been widely addressed so far. I noticed that, especially mainly in the academic scholarship, the focus is on whether AI generated outputs should attract copyright protection or not, and about the ownership of the works. But there are not many. There are not many works addressing the issue of liability. So in this case, who should be liable for AI generated unauthorized works? For instance, if the output has substantial similarities with existing content that has been used in order to train the AI model. So who should be liable? Is it the provider? Is the AI provider? Is it the user that inputs the prompt? So at the end, and also what type of liability? Is it primary liability? Is it secondary liability? There is at this stage the AI liability directive, a proposal for an AI liability directive, but this has not been yet finalized, and I'm not aware when this will be finalized. So this could also address these issues, the issue of liability. But I think that the question of liability is of equal importance to the debate as to whether AI generated outputs should attract copyright protection or not.
I think it's very interesting that you brought liability, because it's something that I honestly don't see that often being discussed. I can see a lot of discussion about whether it should be protected or not, but the liability was a very interesting angle that you brought.
The issue of liability aligns with my research at the moment. I'm trying to implementing all the online the legal framework of online platforms into the context of AI, and view all these AI models as online platforms. See whether the current legislation on online platforms could be applicable also in the AI context. So this is what I'm doing. My research is focusing on. So I think the issue of liability of the infringement is a big issue, and should also be further addressed.
Your research sounds very interesting, and I would like to have the possibility to read it in the future.
Yes, you have to send it to us once it's ready.
So, in your experience, how have you seen AI challenge the traditional ways we think about intellectual property protection? Can you share any specific examples that perhaps stand out to you?
Well, the advent of all these generative AI tools force us to reflect further on the long-standing principles of the fundamental principles that underpin intellectual property law, to dig deeper, actually, to test our assumptions about the principles that govern intellectual property law, and in particular with regard to copyright law. For instance, the advent of AI tools challenge the concept of originality. So, what is meant by originality in the context of AI generated outputs? We are using principles and interpretations of the existing case law and legislation in order to implement them into the context of AI. So, what is meant by originality in the context of AI generated output? And also, another principle that is challenged by the use of AI is the idea expression dichotomy, which is a long standing principle of intellectual property law. For instance, copyright protects the expression of the idea. It does not protect the idea itself. So the idea, it's free and anyone can express it, communicate it in its own way. But in the context of AI, the user has the idea, and then the AI tool contributes to the creative process. The AI model generates automatically the work that copyright traditionally rewarded. So it seems difficult. It is questionable whether the idea expression dichotomy is still relevant, and how this could be also applicable in the context of AI. So that's why, as we have addressed also at the beginning, this is a very complicated debate. The advent of AI has definitely challenged a set of traditional principles of intellectual property law.
There is something that we are doing on this AI special. We are also interviewing some SMEs and CEOs from startups that are using AI or are developing different tools based on AI. And I was wondering, because it has always been important, obviously, for SMEs, artists, and entrepreneurs to understand the role of IP in their work and creations. However, with AI, things need to be clarified. Do you think is this challenge bigger now that they have to face the rapid development of AI technologies?
Well, I think it is. I think that now with the advent of AI, things need to be clarified. It's urgent, actually, to be clarified. Um, this is as I said before, this is a very complicated debate. This intersection of AI and intellectual property rights, and this is also evidenced through a number of lawsuits that are ongoing at the moment, especially in the U.S. jurisdiction, with authors. Brought legal proceedings against AI developers for using unauthorized their copies of their work without their permission for training the AI models. So I think that my advice with regard to the creators would be, first of all, to be aware of the collective licensing mechanisms that exist, and manage how their works are used by AI providers, and secondly, to be aware of copyright exceptions, especially at the European level, the text and data mining exception. Also, looking at the EU AI Act, there is in the transparency obligations that are imposed on the AI models, on the general purpose AI models. There is an obligation to put in place policies that comply with European copyright law, and especially Article 4, Paragraph 3 of the Copyright in the Digital Single Market Directive, where right holders, they can reserve their rights, they can withdraw their data from these training data sets. So I think this is important for SMEs and for artists and entrepreneurs to be aware of the opportunities that they have in order to safeguard their rights. It is important to empower, as I say, the creators, and not let the creators not let the AI to be at the expense of the creators' rights.
Sure. Yeah.
So we are unfortunately reaching the end, but I do have one more question for you. And as you said, AI poses so many challenges for intellectual property rights. There are so many questions that need to be answered somehow. As someone at the forefront of academia and practical law, what excites you most about the future of AI and IP? Where do you see the most significant opportunities for innovation and collaboration in the next few years?
Well, I think that the big things for AI are yet to come.
Mhm.
But we really need to address these complicated debates because with the advancement of AI technology, these debates might be even more complicated. So we need to address these complicated issues, debates at this stage at least. And given that given the ultimate beneficiaries of intellectual property law and AI are the end users, so the general public, I think it is important to craft legislation that balances the rights of the creators, the rights of the users, the end users, the rights of AI providers. So in this light, I see significant opportunities in terms of collaboration and innovation in the field of AI and intellectual property law. So, as to give you two examples, on the one hand, with regard to copyright, AI can be used in order to identify copyright infringements. So, all these automated content identification systems, such as the Content ID from YouTube, although it has a number of flaws and errors, of course. It can identify copyright infringement by scanning all multiple files that exist that have been submitted in the database. So in that way, AI can be used in order to identify copyright infringements. And on the other hand, with regard to trademark law, I'm aware that many brand owners they are using AI in order to uh, identify trademark infringements, so scanning websites for counterfeit goods. And even with regard to trademark registrability, to using AI tools in order to identify existing conflicting trademarks. So in a way, this could help the collaboration between AI and intellectual property law. And as I said before, because the ultimate beneficiaries of AI and intellectual property law are the end users, so the general public, both fields, so intellectual property law and AI, they should work with each other. Not they should be complementary. They should not work against each other. So, and this will create more opportunities for further collaboration, like turning all this complicated debate, all these challenges into opportunities. I think that this will help intellectual property law to promote not only human creativity but also AI innovation. So this is my conclusion.
That was a great conclusion. And thank you so much, Zoe, for being here with us today. We really appreciate you taking the time to answer all our questions and to provide such interesting answers.
Thank you so much for inviting me. It was a pleasure to talk to you.
Bye bye.
Bye.
Thank you for listening to IP Stories by 4IP Council. Visit our website on 4ipcouncil.eu to find out more and check out the links mentioned during this episode. If you liked it, remember to share and subscribe.